The Residential Tenancies Act lays out various rights and responsibilities for both landlords and tenants and covers a number of smaller issues that you may not realize are governed by a specific set of rules. So today we're exploring who's responsible for maintenance, modifying a rental home, and a question that we see come up most often, which is, can a rental lease ban pets?
A landlord cannot ban pets in the lease. Under Section 14 of the Residential Tenancies Act, that is not a provision that can be included in a lease.
Ademofe Oya Adinira, a lawyer with the Canadian Centre for Housing Rights, says it is possible that a tenant's application could be refused if the landlord doesn't want pets in the home, and there are no official rules against that. But existing tenants cannot be refused pets unless
if the pet is causing damage in the residential unit or the residential complex, you can have that pet. If someone in the residential complex or in the area in that building has allergies to the pet, then they can't have that pet as well.
Landlords can file an application with the Landlord and Tenant Board and present evidence to have such pets removed. Condos, on the other hand, have their own bylaws that can legally ban pets or impose size and weight restrictions. However, service animals are exempt and must be accommodated by all housing providers. What are the kind of things that tenants need to watch for when it comes to modifying the home? Let's start with painting.
You are allowed to paint your unit. I think that some landlords don't mind if you inform them, but it would be a good idea to return it to the color that it was. And with regards to modifying the unit in general, you want to think about your reasonable enjoyment of the unit. What would you like to do in order to make yourself comfortable and to reasonably enjoy the space?
Putting up art and photographs and similar decorative changes are acceptable.
But you want to make sure that you can put the unit back into the state that it was in when you moved in. So, for example, if you poke holes in the walls, you want to make sure that that is covered. You want to think about the landlord's rights as well in terms of putting things back in the state that they were in.
But apart from that, tenants are not responsible for general maintenance, and any clauses in the lease that suggested are void.
With regards to snow removal and lawn maintenance, the landlord is responsible for that. Now, a tenant can make an agreement with a landlord to be responsible for that, saying that, I would maintain the lawn or remove the snow, and this is the compensation that I will receive in turn. But you can't have a provision in the lease saying that you have to maintain the lawn or remove the snow or your tenancy is over.
The landlord is also responsible for repairing or replacing any damaged or broken appliances.
Now, if they believe that it's the tenant's fault, they can file an application at the LTB to recover costs for that.
In general, tenants are not considered at fault for reasonable wear and tear, but can be held responsible for damage caused due to negligence. Dilshad Burman, City News.